Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a landmark judgment, the Supreme Court Constitution Bench unanimously ruled that Election Commissioner and Chief Election Commissioner shall be appointed by President on recommendation of a three-member committee consisting of Prime Minister, Opposition Party Leader, and in his absence, the Leader of the Opposition Party with majority and the Chief Justice of India. The five-judge bench headed by Justice K.M. Joseph observed that the independence of the Election Commission is paramount and the institution cannot claim to be independent and then act in an unfair manner. The court established that this system of appointment will be in place until Parliament comes up with a law for these appointments. The court established that this system of appointment will be in place till Parliament comes up with a law for these appointments, stating that core values of the Constitution, including democracy and the rule of law, are being undermined. The court allowed petitions seeking an independent mechanism to appoint the CECs and ECs. The bench, also comprising of Justice Ajay Rastogi, Justice Anuruddha Bose, Justice Harishikesh Roy and Justice C.T. Ravi Kumar, rejected the prayer to grant the same protection as is available to the CECs in the matter of removal from office to the ECs too. The Supreme Court ruling for now will bring an end to the decade-old practice of the CECs and ECs being appointed on the advice of the Council of Ministers as laid down in the Constitution. According to Article 324(2) of the Constitution, the CECs and ECs shall be appointed by the President with the aid of the advice of the Council of Ministers till Parliament enacts a law fixing the criteria for selection, conditions of services and tenure. The top court has ordered setting up a committee headed by ex-Supreme Court Judge Justice A.M. Sapare to probe the recent Adani Group shares crash triggered by the Hindenburg Research's fraud allegation. The court has asked the market regulator SEBI to conclude its investigation within 2 months into whether there has been a violation of Section 19 of the SEBI rules and whether there was any manipulation of stock prices. The expert panel will include former Judge A.M. Sapare, K.V. Kamath, Nandan Nilekani, Someshkar Sundaresan, O.P. Bhatt and retired Justice J.P. Devadhar. The Supreme Court has further said that the remit of the committee will be to suggest measures to strengthen framework to investigate Adani Row and to suggest measures to strengthen the statutory framework. The court has directed SEBI to ensure that all information is provided to the committee and that the report should be submitted in a sealed cover before it in 2 months. In a significant verdict, the Supreme Court has held that a High Court can transfer a civil lawsuit from one state to another if that High Court is common one and has jurisdiction over both the states. The judgment came on a pristinely legal and novel issue as to whether the Supreme Court is the sole repository of power under Section 25 of the Civil Procedure Code to direct a transfer of a suit, appeal or other proceedings from a civil court in one state to civil court in another. The court observed that the Apex Court bench comprising of Justice Harishikesh Roy, Justice Dipankar Datta referred to relevant provisions of the CPC and ruled that the Apex Court is the sole authority to transfer civil cases from one state to another if the jurisdictional high courts are different. The Supreme Court has ruled that its power to transfer criminal cases under Section 406 Criminal Procedure Code extends to offences under Section 138 of the Negotiable Instrument Act. The division bench of Justice Dinesh Maheshwari and Justice Sanjay rejected the contention that the non-obstacle clause in Section 142(1) of the NIA Act would override Section 406 CrPC, and that it would not be permissible for court to transfer the check bounce cases under Section 138 of the NIA Act. The court clarified that insertion of Section 142(2) and 142(a) via 2015 amendment in the NIA Act was a direct consequence of the judgment of Dashrath Roop Singh Rathod versus the state of Maharashtra and others, and therefore the use of the phrase shall be inquired into and tried only by a court within whose local jurisdiction in Section 142(2) of the Act of 1881 is contextual to the ratio laid down in Dashrath Roop Singh Rathod to the contrary, whereby territorial jurisdiction to try an offence under Section 138 of the Act vested in the court having jurisdiction over the drawee bank, not the complainant's bank where he had presented the cheque. The Supreme Court has held that a lawyer with a bachelor's degree and a professional experience of at least 10 years in consumer affairs, law, public affairs, administration, etc. is eligible for appointment as president and member of the state consumer commissions and district consumer forums. A division bench of Justice M.R. Shah and Justice M.M. Sundaresh has upheld the Bombay High Court judgment quashing the provisions of Consumer Protection Rules 2020, framed by central government under Section 101 of Consumer Protection Act 2019, which prescribes a minimum professional experience of 20 years and 15 years for adjudicating members to the State Consumer Commission and District Consumer respectively, and which did away with the requirement of a written exam for appointment. The court opined that Rule 6.9 lacks transparency and confers uncontrolled discretion to the selection committee, whereby they are accorded with way more discretion as to determine procedure to recommend candidates to be appointed as president and members to the state and district commission. In the matter of Punjab Budget Session Slug-fest, a division bench of CGI Diva Chandrachud and Justice P.S. Narasimha observed that Governor is duty bound to summon the budget session of the Assembly once the State Cabinet recommended for it. It also added that the Chief Minister is equally duty bound to furnish the information sought by the Governor under Article 167B of the Constitution. The bench remarked that the political differences in a democratic polity is acceptable and has to be worked out with a sense of propriety and maturity without having to race to the bottom. Unless these features are adhered to, constitutional principles will be put in jeopardy, it added. Next we have Delhi High Court. In major decision, the Delhi High Court has upheld the centre's new Agnipath scheme for recruitment in the defence sector. Pointing that scheme was a policy decision on the basis of national security, a bench headed by Chief Justice Satish Kumar Chandra dismissed the petitions challenging the constitutional validity of the Agnipath scheme. The court further dismissed the petitions challenging the 2019 recruitment notification/advertisements, saying that no promissory estoppel or legitimate expectation was created by the advertisements for the recruitment and the petitioners cannot claim a vested right in the same. The Delhi High Court has said that it is not acceptable for parties to cast aspersion on the integrity of the judge on account of facing anxiety during the trial. The single judge bench of Justice Manmeet Preetham Singh Arora, while accepted an unconditional apology tendered by one such litigant who represented himself in a case filed by his former wife and during the course of it made unceremonious remark against the presiding judge, also imposed a cost of ₹5,000. The court further warned that if in future the respondent similarly cast aspersions on the integrity of the court in any legal proceeding where he is a party, the record of the present contempt petition shall be read in evidence and the subsequent conduct will be considered as an aggravated contempt of the court within the meaning of the Section 2C of the Contempt of Courts Act 1971. The Delhi High Court has showed its reservation on parties filing complaints against the opposite counsels over insubstantial issues. Justice Pratibha M. Singh in one such matter observed that lawyers being put to harassment and frustration due to repeated bar counsel complaints cannot be countenanced unless the serious case of misconduct is made out. In backdrop of one such complaint, the court expressed that it has noticed that with some concern that on a regular basis there are several petitions which are filed relating to complaint against advocates where Bar Council of Delhi is delaying the examination of the same. The court in this view directed the BCD to place on record a detailed chart giving the details of all pending complaints against advocates which shall include the dates of filing those complaints and the dates of first notices in all the matters within 6 weeks. A PIL has been filed in the Delhi High Court seeking to restrain cow slaughtering and demanding constitution of cow protection units in every district of the national capital. A division bench of Chief Justice Satish Kumar Sharma and Justice Subramania Prasad has issued notices to the centre state government as well as the Delhi police and has sought their reply. The petitioner activist stated that his intention is to stop the clashes that repeatedly breaks out between the two sides and argued that the constitution of these units will be beneficial to both the people who are slaughtering cows and those who work to protect them. He pointed out that despite heavy police force being deployed in the national capital, the incidents of cow slaughtering are increasing rampantly. Now let's have an overview of other high courts. The Bombay High Court, while dismissing petition challenging an application filed by wife under Section 125 Criminal Procedure Code, has observed that mere willingness of husband to live with wife cannot be a ground to deny her maintenance. A single judge bench of Justice Bharti Dangre observed that merely saying that the husband was and is always ready to and willing to cohabit is not sufficient ground to absolve him of the liability to pay maintenance. Referring to the statement of wife, where she stated that several instances of mental and physical torture occurred to her in cohabitation with her husband, the court clarified that although Section 125(4) CrPC disentitles women from claiming maintenance if she is living in adultery or if, without any sufficient reason, refuses to live with her husband, or if they are living separate by mutual consent, the reasons she is providing has to be rationalized. The Orissa High Court has reiterated that for counting the loss of dependency, where the business entity subsists even after the death of the deceased and is managed by the dependents, the managerial skill and expertise of the deceased to run the business is to be considered along with specific facts and circumstances. Justice Bibhu Prasad, in view of the recent Supreme Court ruling establishing the particular position in motor accident claim cases, rejected the appeal filed by appeal filed against amount of loss of dependency calculated by the tribunal. It cited Sushma HR and others versus Deepak Kumar Jha and others, and Ramya and others versus National Insurance Company, wherein it was observed that appropriate approach is to determine the value of managerial skills along with any other factual consideration in terms of calculating loss of dependency. The Madras High Court, while hearing a petition to quash the order of the magistrate for registering an FIR, held that when a complaint contains material particulars and an order for FIR is passed without mentioning the reasons of prima facie satisfaction, then it cannot be quashed just because the reasons were absent. The court differentiated the present case from Priyanka Shrivastava versus State of Uttar Pradesh and others, and noted that the allegations as made by the complainant were sufficient enough to make out a case for sexual harassment in the workplace and or any other related offences. The complainant had also produced the message sent by the petitioners as a document with the petition, so it cannot be said that the allegations were bald and the court gave the order without any basis, it asserted. The Chhattisgarh High Court has reiterated that a police officer should not re-record a dying declaration that has previously been recorded by an executive magistrate who has the legal power to do so under Section 164 CrPC. After pursuing the evidence on record, the court opined that in the absence of certification by a doctor and in the absence of satisfaction recorded by the executive magistrate while recording the dying declaration, that the deceased was mentally and physically fit to give the dying declaration, and the presence of the deceased's parents, particularly the mother, holding her, and the presence of police personnel at the time of making the dying declaration as the possibility of her being influenced cannot be ruled out. The court was startled to learn that only an hour after the first dying declaration was recorded by a legally competent authority, that is the executive magistrate, a head constable went on to record the second dying declaration. The Rajasthan High Court has reiterated that driver of a vehicle holding light motor vehicle license is permitted to drive transport vehicle. The single judge bench of Justice Rekha Borana referred to the ratio laid down in Supreme Court ruling in Mukund Devangan versus Oriental Insurance Company and rejected the appeal preferred by the insurance company challenging the order issued by Motor Accident Claim Tribunal, whereby it made the company partly liable and directed it to pay and recover. The court noted that the tribunal only partly allowed the issue in favour of the insurance company on the ground that the driver was driving a transport vehicle, whereas he was having a driver license for a light motor vehicle, in breach of the conditions of the insurance policy. Moving on to miscellaneous news. In a big step to restore confidence of trial court judges, the Supreme Court has strongly deprecated the domineering practice of High Court judges seeking explanations from the district judicial officers for passing certain orders and said that such actions affect the independence of district judiciary. The Supreme Court has dismissed a PIL filed by BJP leader and advocate Ashwini Kumar Upadhyay seeking to rename historical places and cities which he suggested are named after the invaders. A division bench of Justice K.M. Joseph and Justice B.V. Nagaratna apparently took exception to contention in the petition and remarked that India is a secular country now and history shouldn't be relooked selectively to point fingers at one particular community. The bench also ascertained the settled legal position on the issue by the Supreme Court only, wherein a 9-judge bench had ruled that a country cannot remain prisoner of its past. The Bar Council of Uttar Pradesh has expressed resentment over the brutal killing of a lawyer and has demanded the reinforcement of Advocates Protection Act in the state so that the life of lawyers can be protected in future. In a letter to the CM, President of the Bar Council of UP, Panchu Ram Maurya warned if adequate steps are not taken by the state government for protection of the lawyers in the state, the Bar Council would be compelled to launch an agitation in the connection. Delivering the keynote address at the convocation ceremony of the Nalsar, Hyderabad, one of the 24 NLUs in the country, CGI Diva Chandrachud flagged his concern about the sense of entitlement prevailing among the NLU students. He thus advised the NLU students that they should not look down upon students from other law colleges and shouldn't work in isolation. He also highlighted the need for creating empathetic environments in campuses so that discrimination towards students from marginalized communities, particularly Dalit and Adivasi students, could be eliminated. The Supreme Court has prima facie opined that the norm of appointing 1/3 of the High Court judges from the district judiciary through the service quota and resourcing the remaining ones from bar should be continued. A 3-judge bench of Justice B.R. Gawai, Justice Vikram Nath and Justice Sanjay Karol recorded that prima facie that the status quo should be maintained and followed while also seeking responses from all the high courts and state governments in the matter. With live-in relationship emerging in India at the social scenes, its clash with the traditional system is nothing but obvious, and so are the issues that it will create in terms of transition, acceptance, legitimacy, etc. Keeping the above as center issue, a PIL has been filed in the Supreme Court seeking to frame rules and guidelines for registration of live-in partnerships in India. The courts have been favorable of the new social setting and has gained popularity over the past few years and is slowly becoming the norm. In many decisions, the court has recognized it and also tried to balance its intricacies with the laws of the land. Advocate Mamta Rani in her petition has also reckoned the same and urged the top court to direct centre to formulate rules for registration of live-in partnerships. 3 of 4 men accused in the 2020 Hathras case, in which a young Dalit woman was raped and murdered by her so-called upper caste attackers, has been set free by a UP court. The fourth one was found guilty of culpable homicide, not amounting to murder and under sections of SC/ST Act but not of rape, reports indicated. In the end, we have international news. An American computer scientist has urged the United Kingdom's Supreme Court to rule that he is entitled to the patents over invention created by his artificial intelligence system in a landmark case about whether AI can own patent rights. Stephen Thaler wants to be granted 2 patents in UK over inventions he says were devised by his creative machine called Dabus. Harvey Weinstein has been sentenced to 16 years, effectively ensuring the former Hollywood mogul and convicted rapist will spend the rest of his life behind bars. Weinstein's sentencing was held in downtown Los Angeles nearly 2 months after his Los Angeles trial concluded with the jury convicting him on 3 counts of rape and sexual assault. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.